Morning, everyone. Let us continue with the topic protection of wildlife in India. In the previous session, we saw what do you mean by wildlife, what is wildlife conservation, what is the need to protect wildlife, and the legal framework in respect of the protection of wildlife in India. We saw the constitutional mandate as well as the specific statute which is intended to protect the wildlife in India, that is Wildlife Protection Act of 1972. And we saw the history behind that statute as well as the major provisions, including the most important definition clauses with regard to that statute. And we saw what is hunting, in which all circumstances hunting is permitted. So basically, what I have to say right now is without going through the first part of this lecture, you will not be able to understand the second part. So make sure that you go through the first part in the beginning and then come to the second lecture. And also, before starting with this, you'll have to go through the B.A.LL.B Act. Then only you will understand the scheme and arrangement of the sections as well as different parts which has been inserted into the main statute through various amendments. So make sure that you read that or at least go through the B.A.LL.B Act before you listen to this lecture. So in the previous lecture, we had completed chapter 3 as well as chapter 3a. Till chapter 3a we have completed. Now we'll move on to chapter 4, which is again very important. That is with regard to declaration of sanctuaries, declaration of national parks, as well as closed areas by the governments, both the state government as well as in certain situations the central government. So let's see in detail what are the provisions with regard to how a sanctuary can be declared by the state government and what all restrictions are being imposed upon with regard to a sanctuary, an area which is designated as a sanctuary. Then let's see what are how the declaration of national parks are being done and what is this closed area, etc. So we'll deal with these provisions in detail. So firstly, we'll deal with the sanctuaries. How a sanctuary or an area is to be declared as a sanctuary, and it is mentioned from sections 18 onwards, which falls in the chapter 4 of the statute. So here the state government may, so you should understand the power is vested with the state government and it is also a discretionary power. The word used is state government may by notification declare its intention to constitute an area other than an area comprised within any reserved forest or the territorial waters as a sanctuary. So here it is the discretion of the state government to declare its intention to constitute a particular area as a sanctuary. But there are two exceptions given here. One is which it shall not be a reserved forest. I hope you remember what do you mean by reserved forest. We had discussed this term under the Indian Forest Act 1927. So the area which in which the state government wishes to declare or constitute a sanctuary should not be a reserved forest or it shall not be territorial waters. And if the state government considers that such area is of adequate ecological, faunal, floral, geomorphological, natural or zoological significance, or for the purpose of protecting, propagating or developing wildlife or its environment in such circumstances. So this is a basic requirement that state government should identify or find that particular area which they are about to declare as a sanctuary should be of great importance in the terms of ecological, floral, faunal, geomorphological, zoological, etc. And such notification shall specify as nearly as possible the situation and limits of such area. So whenever the intention is being notified, then the state government should specify its boundaries or borders to the maximum possible extent. So what are the conditions for declaration of a sanctuary? So the first thing to be noted here is, firstly, a notification has to be issued by the state government. I was referring to this notification in the previous slide also. So a notification has to be made or issued under section 18 by the state government. declaring the intention and boundaries of a particular area that is required to be declared as a sanctuary. So state government, when it is found that it is interested in declaring a particular area as a sanctuary, first thing to be done is it has to issue a notification, and in that notification the state government should declare that intention that we are going to declare this particular area as the sanctuary, as well as the boundaries of that area as far as possible. Then the second condition is that 2 months period has to be completed, and within that 2 months period, if at all any individual has any claim or claim of rights over that property, that has to be entertained, and all the claims made in relation to any land must be disposed of by the state government. So if at all there is any claim by any private individual that they have some interest over that particular area which is supposed to be declared as the sanctuary, that those claims are to be settled within a reasonable time. And after these conditions are fulfilled, the state government is required to issue a notification specifying the limits of area that would finally be notified as a sanctuary. So after fulfilling all these three requirements, that is, firstly, the intention should be notified. Then in that intention, the boundaries also has to be specifically mentioned. Then 2 months period has to be given if there is any claim on that particular area, that has to be looked into, and it has to be disposed of as soon as possible. And then once all these claims are settled and disposed of, then the government the government is required to issue another notification specifying the limits of the particular area, the boundaries of the particular area that would finally be notified as a sanctuary. So what are the after effects of declaring a particular area as a sanctuary? What all restrictions can be imposed in a sanctuary? That is mentioned under section 27 of the statute. In that particular section it says that only the following persons can enter or reside in a sanctuary. So generally no one is allowed to enter or reside in a sanctuary, with a few exceptions. And who are those persons who can or who may enter and reside in a sanctuary? First category is a public servant on duty. A public servant on duty may be permitted to enter or reside in a sanctuary. Secondly, a person who has been permitted by the chief wildlife warden or other authorized officers to reside within the limits of the sanctuary, maybe for the purpose of maybe they are officials from the forest department. So in such situations, the chief wildlife warden or any other authorized officer may permit such person to reside within the limits of the sanctuary. Thirdly, a person who has any right over the immovable property within the limits of sanctuary. So when the notification for intention was issued, there was a condition where or a situation where you can, if any private individual has any particular claims over that property, they may contact or they may approach the state government, and if that um, proprietary rights or any particular right has been established, such a person can enter into the sanctuary where they have any right over the immovable property within the limits of that sanctuary. So that has to be already established by the state government. Only such people can enter. Fourth category is a person passing through the sanctuary along a public way. You can see public highway. You can see many states, these public highways may be passing through the sanctuaries. In such a situation, the person can pass through the sanctuary along a public way. Here you should note, they don't have the right to reside in the sanctuary. You can just simply transit through the sanctuary along a public way. And also the dependents of the persons referred to above. So if all the dependents of public servants or authorized persons or persons who has an immovable claim over an immovable property, all these persons, dependents also has an access or a right to enter into the sanctuary. We'll see who all can be given permission to enter in a sanctuary. That is specified in section 28 of the statute. It says that the chief wildlife warden may grant to any person a permit to enter or reside in a sanctuary for the following purposes. So, this is the exclusive discretionary power which is vested with the Chief Wildlife Warden, wherein he may permit any of these following persons to enter or reside in the sanctuary for the purposes specified below. What are those purposes? One, investigation or study of wildlife. Obviously, for that they'll have to be permitted to enter into the sanctuary. So, investigation or study of wildlife. Secondly, photography, wildlife photography and all, in order to for that purpose also they may be allowed to get into the or enter into a sanctuary. Thirdly, scientific research. Fourthly, tourism. For tourism, also certain areas are being earmarked and designated. They may be permitted to enter into that area and with a lot of restrictions for sure. Then transaction of lawful business with any person residing in the sanctuary. So I've already mentioned that there are certain categories of persons who may be permitted to reside in a sanctuary. Say for example, a forest guard or any official of forest department. They may be staying inside the sanctuary permanently. So any transaction of lawful business with any such person who is residing in the sanctuary. Then the permit to enter or reside in a sanctuary shall be issued subject to such conditions and or of payment of such fee as may be prescribed. So you cannot just claim for complete power or authority to enter into the sanctuary. It will be always restricted and a lot of conditions will also be imposed while you enter a sanctuary. Those who have visited any sanctuaries may be knowing this. If you are driving through the sanctuary, what all precautions are to be taken, what all conditions are to be followed, all these are very common. So these conditions will be definitely imposed upon you, plus you may have to pay a prescribed fee also. Then under section 29, it says that such person shall not destroy, exploit or remove any wildlife from the sanctuary. It doesn't mean that because you are permitted to enter into the sanctuary, you can do whatever you want to. No, it is not like that. Those persons who are permitted to enter into a sanctuary shall not destroy, exploit or remove any wildlife from the sanctuary. And they shall not destroy, damage the habitat of a wild animal or its habitat within the sanctuary. So these are the conditions which automatically comes along with the permission which is granted to enter in a sanctuary. Now let's see what are the prohibited activities in a sanctuary. What are things are completely prohibited? So under section 30 of the statute, causing fire to a sanctuary is completely prohibited. Under section 31, entry into sanctuary with weapons. So if you are given permission to enter into the sanctuary, that doesn't mean that you can do whatever you feel like doing in the sanctuary. So there are certain prohibitions as well as restrictions. So here causing fire is completely prohibited. Then entry with weapons is also completely prohibited. Then use of injurious substances which may cause injury or endanger any wild animal in the sanctuary, that is also prohibited. So these are complete prohibitions. You are not supposed to cause any fire or use any weapons, or you are not even supposed to enter into the sanctuary with weapons, and also you are not supposed to use any substance which may endanger any wildlife. That is also completely prohibited. And section 33, it says that the chief wildlife warden shall be the authority who shall control, manage and maintain all the sanctuaries. So he is the sole authority who has the power to control, manage and maintain all the sanctuaries. So we have already seen how sanctuary is to be declared by the state government, and now we'll move on to the declaration of national parks. So this is the second category of protected areas which is mentioned under the Wildlife Protection Act. So first one being sanctuary, second one is national parks, and the entire thing is mentioned in section 35. And it says that whenever it appears to the state government that an area, by reason of its ecological, faunal, floral, geomorphological or zoological association or importance, needed to be constituted as a national park for the purpose of protecting, propagating or developing wildlife, therein or its environment, the state government may, by notification, declare its intention to constitute such area as a national park. So the procedure, the entire procedure is not that different from what we have already seen with regard to the sanctuaries. And no alteration of boundaries of a national park shall be made except by a resolution passed by the state legislation. So state legislature. So the all the almost all the steps and procedures which are to be followed while declaring a particular area as a sanctuary is to be followed here also. And one important thing you need to understand here is no alteration of boundaries. So once if a particular area has been declared as a national park through a notification, then such boundaries cannot be altered except by passing a resolution by the state legislation. What all activities are completely prohibited in a national park? It is mentioned in section 35 clause 6. It says that no person shall destroy, exploit or remove any wildlife from a national park. So any person entering in a national park is not supposed to destroy, exploit or remove any wildlife from that national park. Then that person shall not destroy, damage the habitat of any wild animal. And whenever I use the term wild animal, you should remember the definitions. Okay, so all these, even a nest or taking away of the eggs from a nest, that is also covered under this section, because we know the definition of the term animal that even includes birds, reptiles, their nests and their eggs also. So even if you disturb a nest of a bird, that also amounts to destroying or damaging the habitat of a wild animal. Then no person shall deprive any wild animal of its habitat within the national park. So these are the prohibitions. But there are certain exceptions. In certain exceptional situations, you can do certain activities, but it should be in accordance with the permission which is granted by the chief wildlife warden, and such permission shall be given only with the approval of the state government. So if something contrary has to be done, it has to be done only with the permission of the chief wildlife warden. And when he gives such a permission, he should also get the approval from the state government, and the state government shall be satisfied that such destruction or exploitation or removal of wildlife from the national park is necessary. So in certain unavoidable circumstances it may be permitted, but that has to be done only with the permission and prior approval of the state government. And after getting the approval, the chief wildlife warden may permit such activities. And there are certain other prohibitions also. No grazing of any livestock shall be permitted in a national park. So you are not supposed to send your cattle or bullocks, etc., to be to enter into the national park for grazing. And no livestock shall be allowed to enter the national park except such livestock which is used as a vehicle by a person authorized to enter the national park. So generally livestock are not allowed to enter into a national park, but if the person who is living in uh, the sanctuary or the national park, that person is using this livestock, say for example bullock carts, so in such situation it may be permitted, otherwise no. So another category of closed areas mentioned in the Protection Act is closed areas, which is mentioned in section 37. But at the very outset, you need to understand this particular provision has been omitted by the Wildlife Protection Amendment Act of 2002. So as of now, there is no area which is earmarked as closed areas. But as it was enacted, there was this provision for closed areas also. So we had seen that the state government is empowered to declare sanctuary or national park. But here under section 38 of the statute, it empowers the central government to declare areas as sanctuaries or national parks. So it is not just the state government, even the central government may declare a particular area as sanctuary or national park. So what are the conditions for that? In order to declare a particular area as a sanctuary or national park by the central government, certain conditions are to be followed. What are those conditions? Firstly, the state government must either lease or transfer any areas under its control to the central government which is not already a sanctuary. So if at all the state government has transferred or leased some of its areas to the central government, but that area should not be already declared as a sanctuary or as a national park. But one more condition is there, which is very important. The central government must be content by the fact that that particular area satisfies the conditions under section 18 and section 35 of the statute, that is because of its geological, geomorphological, faunal, floral significance. It is important that this particular area should be converted or declared to be a sanctuary or national park. So similar provision can be seen under section 38 clause 1 where the central government may declare a particular sanctuary. And under section 38 clause 2, you can see where the central government can declare a particular area as a national park. The conditions are one and the same. That's all with regard to chapter 4, which discusses the declaration of sanctuaries, declaration of national parks, closed areas, the prohibitions and regulations in such areas, etc. Now we'll just quickly see what all are the upcoming chapters in the statute. Chapter 4A speaks about Central Zoo Authority and the recognition of zoos. I hope you remember the definition which we have learned for the term zoo. Then chapter 4B speaks about the constitution, powers and functions of National Tiger Conservation Authority. And chapter 4C, Tiger and Other Endangered Species Crime Control Bureau. Chapter 5, Trade and Commerce in Wild Animals, Animal Articles and Trophies. Chapter 5A, Prohibition of Trade and Commerce in Trophies, Animal Articles, etc. derived from certain animals. Chapter 6 speaks about prevention and detection of offences, and we have chapter 7 which speaks about miscellaneous things. Okay, so one thing why I've put the names of these chapters here is you can see chapter 4A, B, 4C, all these are introduced into the statute through various amendments from time to time. Then 5A also you can see this was also inserted in an amendment. We'll discuss these provisions in detail, and you should also recall chapter 3A that was also inserted to the main text through an amendment. So let's move on to chapter 4A, which speaks about Central Zoo Authority, Constitution of Central Zoo Authority, what are the powers of Central Zoo Authority, then recognition of zoos. So this chapter is introduced or inserted into the statute by 1991 amendment, and the sections are 38 capital A to 38J. So here 38A, it says that a central zoo authority has to be created by the central government. And what is the purpose behind such an authority? It is to regulate zoos and ensure that the activities therein do not result in destruction of wildlife. This is a particular chapter which specifically deals with the recognition of zoos, then establishment of zoos, licenses to be procured for conducting a zoo, etc. So one of the primary functions of the authority is to encourage captive breeding of endangered species in zoos. So there are endangered species, so you'll have to collect the specimens of these endangered species and try to encourage captive breeding. So that is one important objective of this particular zoo authority. Then it also speaks about the composition, powers and functions. One interesting fact you can see throughout the statute is in this one single statute, you can see n number of statutes, which n number of authorities which are established, all for the purpose of protecting and preserving the wildlife. Then section 38H, it says that no zoo shall be operated without being recognized by the authority, and the entire procedure, giving application, how the application has to be filed, what all things are to be supported. So all these procedural formalities are being mentioned in the 38H. Then we have section 38I. It speaks about acquisition of animals by a zoo. For that also previous approval of the authority is required. And 38J, it speaks about the obligation or a duty or the duty of persons who visit the zoos. That is, no person shall tease, molest, injure or feed any animals or cause disturbances including noise, disturbance, etc. in the zoo. So these are the provisions with regard to Central Zoo Authority and recognition of zoos. Let's see what are the functions of the Central Zoo Authority. The functions are enlisted here. Firstly, specify the minimum standards for housing, upkeeping and veterinary care of the animals kept in a zoo. Then evaluate and assess the functioning of zoos with respect to the standards or the norms as may be prescribed. Then recognize or de-recognize zoos. Then identify endangered species of wild animals for the purpose of captive breeding and assigning responsibility in this regard to a zoo. Coordinate the acquisition, exchange and learning of animals for breeding purposes. Ensure maintenance of stud books of endangered species of wild animals bred in captivity. To continue with the functions, identify priorities and themes with regard to display of captive animals in a zoo. Then coordinate training of zoo personnel in India and outside India. Coordinate research in captive breeding and educational programs for the purposes of zoos. Provide technical and other assistance to zoos for their proper management and development on scientific lines. Perform such other functions as may be necessary to carry out the purposes of this act with regards to zoo. So these are the functions of the Central Zoo Authority constituted under Chapter 4, capital A of the statute. Next is Chapter 4B, which speaks about National Tiger Conservation Authority. So this is also a new insertion by 2006 amendment, and sections 38K to 38X speaks about the National Tiger Conservation Authority, its composition, powers, functions, etc. So it shall be established by the central government. This authority shall be established by the central government. And the state government may constitute a steering committee under section 38U. It is the discretionary power, it's not mandatory. And why the steering committee is to be constituted is for ensuring coordination, monitoring, protection and conservation of tigers. So as the name suggests, you can understand very well, it is for the conservation of tigers. Then 38V, it makes the state government mandatory to notify an area as a tiger reserve on the recommendation of Tiger Conservation Authority. So tiger reserves has to be, if at all the Tiger Conservation Authority recommends a particular area to be notified as tiger reserves, the state government is duty bound to notify such areas as tiger reserve. Then section 38X, state government shall establish tiger conservation foundation for tiger reserves within the state and to facilitate and support their management for conservation of tigers. So altogether you can understand Chapter 4B intends to create this particular authority which is to be established by central government, and a lot of functions are assigned to the state government as well. And the ultimate aim and objective of this authority is to conserve the tiger reserves in India. Next is Chapter 4C, which is again inserted by 2006 amendment. It speaks about tiger and other endangered species crime control bureau. So this particular bureau is also to be established by the central government, and it is not mandatory. The word used is may. And the central government may constitute such a bureau to be known as Wildlife Crime Control Bureau, and the entire chapter speaks about the composition, powers, functions, etc. And yeah, that's all with regard to this particular Crime Control Bureau, which is known as Wildlife Crime Control Bureau. Next, we'll move on to Chapter 5, which speaks about trade and commerce in wild animals, animal articles, and trophies. Section 39 is the most important section in this particular chapter. it says that, or it declares that wild animals, etc., to be government property. So it is even when we discuss chapter section 11, we saw if at all you hunt a wild animal, that the killed animal is considered to be the government property. So that has been specifically mentioned in this section. It says that wild animal which is hunted or kept or bred in captivity, etc., or any wild animal which is killed by mistake, or any animal article, trophy or uncured trophy or meat derived from any such wild animal. I'm again and again telling you, you should know the definitions very clearly and thoroughly. Then only you'll be able to understand what is an animal article, what is a trophy, what is uncured trophy, etc. So coming back once again, so wild animal which is hunted or kept bred in captivity or killed by mistake, or such animal article, trophy, uncured trophy or meat derivative from such wild animal, or even ivory imported into India and an article made from such ivory, then vehicle, vessel, weapon, trap or tool that has been used for committing an offence and has been seized under the provisions of this act. Not only the body, the dead animal or the killed animal, along with that all the animal articles, and also ivory which is imported, or even something which is made out of such ivory, plus any vehicle or ship or weapon, whatever it is used in order to commit such an offence, which has been seized under the provisions of this act, shall be the property of the state government. So if at all you attempt to do something, that whatever is being used to conduct that crime, everything is being considered as a property of the state government. Where such animal is hunted in a sanctuary or national park declared by the central government, then such animal or any animal article, trophy, uncured trophy, etc., it becomes the property of the central government. So we saw under section 38, even the central government can government can also declare certain areas to be the national parks and sanctuaries. So if such hunted animal is being taken from such sanctuaries or national parks, then such uh, animal or the killed animal is considered to be the property of the central government. Otherwise it will belong to the state government. In addition to chapter 5, a new chapter, that is chapter 5A, has been inserted by 1986 amendment, and the chapter is titled as Prohibition of Trade and Commerce in Trophies, Animal Articles, etc., derived from certain animals. So here, apart from the common provisions which is contained in chapter 5, here certain animals are given priority when it comes to protection and preservation. So sections 49A to 49C is all about chapter 5, and 49A defines scheduled animal. That is very important. What is a scheduled animal? It is an animal specified for the time being in schedule 1 or part 2 of schedule 2. So I mentioned in the previous lecture itself, there are 6 schedules which are attached to this particular statute, and schedule 1, 2, 3, 4 and 5 speaks about different categories of animals, 5 being the list of vermin and 6 being the list of scheduled plants. So among them, the most important or the most endangered species which requires special attention is those animals mentioned in schedule 1 or schedule 2's second part, part 2 of schedule 2. And section 49B prohibits dealings in trophies, animal articles, etc. derived from either a manufacturer who is dealing with scheduled animals, or a dealer in ivory imported into India, or any other article made from such ivory. Then a taxidermist. I hope you remember the definition of taxidermy, which we discussed in the previous class. It is a process of preserving the animal through the process of stuffing the animal. So a person who does that is known as a taxidermist. So a taxidermist with respect to any scheduled animal, then a dealer in the trophy or a dealer in any captive animals, or a dealer in meat derived from such scheduled animal. So all these dealings are completely prohibited under section 49B. So if you are a person who is engaged in these business, you are not supposed to carry on any business with regard to animals mentioned under schedule 1 or part 2 of schedule 2. And you are not supposed to cook or serve meat derived from any scheduled animal in any eating houses. So these activities are completely prohibited, and the term scheduled animal is also defined in section 49A. And you know, those are the animals which are protected with or the priority is much higher when compared to other animals. That is why they are known as scheduled animal, and in order to protect them and prohibit the trade and commerce, a specific chapter has been inserted in the statute, that is chapter 5A. Next is chapter 6, which deals with the prevention and detection of offences. You can see various offences are identified under this chapter, and the punishments also varies. And one important feature you can find with regard to Wildlife Protection Act is, when compared to most other statutes, the penalty imposed in relation to contravention of these provisions are much higher. And you can see even the amount of compensation being or fine being reaching the limit of 50 lakhs rupees. So when compared to other statutes for the protection of environment and all, this particular statute gives stringent punishment. Let's see what are the, and various punishments are given for various offenses committed under the statute under various chapters. So any person who commits a breach of any of the conditions of any license or permit granted under this act, I've told you in various situations permissions are to be granted to do various activities in the national parks, then staying in the sanctuaries, etc. If at all a person who breaches such conditions, he shall be punishable with imprisonment for a term which may extend up to 3 years, or with a fine which may extend up to 25,000, or with both. The next is the offence committed in relation to any animal specified in Schedule 1 or Part 2 of Schedule 2, that is scheduled animal, the most important categories, or where the offence relating to hunting in a sanctuary or national park, or altering the boundaries of sanctuary or a national park. In such situation, punishment is not less than 3 years imprisonment, which may extend up to 7 years, and fine not less than 10,000 rupees. And one more thing is to be added here is, in case of a second or subsequent offence, the term of imprisonment shall not be less than 3 years, but it may extend up to 7 years, plus the fine, which may not be less than 25,000. So in case of continuing contravention, or the second time when the offence has been committed for the second time, the amount of compensation also increases. Any person who commits an offence contravening any provisions of the chapter 5, then the punishment is 3 years imprisonment, which may extend up to 7 years, with a fine that is not less than 10,000 rupees. That any person contravening the provisions of section 38, he shall be punished with 6 months imprisonment, which may extend up to 2,000 rupees. And if he commits the offence for the second time, it will be imprisonment, which may extend up to 1 year, or with fine, which may extend up to 5,000 rupees. And then any person who abets, and if the act abetted is committed, or any person who commits an offence in relation to the core area of tiger reserve, or where the offence relate to hunting in tiger reserve or altering the boundaries of tiger reserve, that is considered to be very severe offence, and the punishment shall be, for first conviction, it will be imprisonment, which shall not be less than 3 years, but it may extend up to 7 years. And also the fine minimum will be 50,000 rupees, which may extend up to 2 lakh rupees. And in the event of second or subsequent conviction, if the offender commits that offence again, Then the imprisonment shall not be less than 7 years and the fine shall not be less than 5 lakh rupees, and it may extend even up to 50 lakhs rupees. That is why I told certain stringent provisions are introduced with regard to penalties under the statute, and it is really a commendable thing, especially when you can see under the Forest Act and all, the punishment is just 6 months imprisonment and 500 rupees. So when compared to that, this is actually a really welcoming provision. So with regard to the protection of wildlife in India, we have already covered the constitutional provisions, then the statutes which were there in the beginning, that is before the constitution came into existence. Then we saw the specific statute with regard to the protection of protection of wildlife, that is Wildlife Protection Act of 1972, and we detailedly examined each and every important provision of that statute. So next aspect that comes in the protection of wildlife is the judicial intervention or the role of judiciary in protection of wildlife. You can see various cases with regard to the protection of wildlife, especially decided by Honorable Supreme Court as well as various high courts. I've mentioned a few here. One is Tarun Bharat Singh versus Union of India, which was reported in the year 1993, decided by Honorable Supreme Court. In this case, the petitioner was a social action group and they filed a public interest litigation for the enforcement of certain statutory notifications issued by the government in the area, which is popularly known as Sariska Tiger Park. And this was declared to be a sanctuary under Wildlife Protection Act. And it was alleged that mining operations were being carried out under licenses which were issued by the state government, which was impairing the environment and the wildlife within the park, within the national park. So this particular tiger park, which was declared as a sanctuary, and a lot of mining operations were going on with the licenses granted by the state government, and it was impairing the environment as well as wildlife within the national park area. Supreme Court directed for the appointment of a committee headed by a retired judge to ensure the enforcement of state notifications and other orders of the Supreme Court to protect environment and wildlife within the protected areas. And it was further directed that no mining operation should be carried on within the specified protected areas. So this was a case of Tarun Bharat Singh versus Union of India, reported in 1993 by Honorable and decision given by Honorable Supreme Court. This is yet another important case which we have already discussed in the class. I hope you remember this. Ivory Traders and Manufacturers Association versus Union of India, reported in a year 1997, decision given by Delhi High Court. And the petitioners here, they alleged that the ban on export of ivory violated their fundamental right to trade guaranteed under 19 clause 1 subclause G of the Constitution. So I hope you remember when we discussed the constitutional provisions, whether this amounts to violation of Article 19 clause 1G, we had discussed this case in detail. And upholding the provision, the court held that the trade business at the cost of disrupting wildlife and linkages necessary for the protection of biodiversity cannot be permitted. Here, the Delhi state issued a notification which completely prohibited export and trade of articles made of ivory. So, and in this particular case, the Honorable High Court declared that notification to be valid and it upheld the validity of that notification. And the court compared trade in ivory to inherently harmful activity like the business in intoxicants. So, the notification which is given by the Delhi High Court with regard to prohibiting the trade in ivory and articles made of ivory was upheld by the Honorable Delhi High Court. So with that, we have completed the lengthy topic, that is protection of forest and wildlife in India, in which we had looked into the protection of forest in the first part. There also we saw the constitutional provisions, specific statutes for the protection of forest, as well as the judicial decisions. I hope you remember the statutes, specific statutes which discussed under the forest protection. One is Indian Forest Act and the second is Forest Conservation Act. Then we moved on to the Wildlife Protection Act, where we saw again the constitutional provisions, then the Wildlife Protection Act in detail, and a few cases in which the court upheld the protection of wildlife as important. So with that, we completed this particular topic, and only one topic is left with under the module 4, that is human rights and environment. We have almost covered everything under that, under the article 21, but still I'll give you a brief outline of what do you mean by, or what is the interrelationship between human rights and environment. After that, we have to complete two more topics that falls under module 5. That is one, public participation and environment impact assessment, and second one is recommendations for a sustainable living. So what is left is 3 more lectures. I'll be finishing all the topics with those 3 lectures. Please go through these lectures which is recorded and given to you. If you have any doubts, please mail to us.